Viewers, welcome back to the show. Before the break, we're talking about this case of Pasqualotto. Now, John, this fellow got injured in 1997 in a car accident for which he didn't claim compensation. Is that correct?
Exactly, Tony, yes.
And Nardine, I hesitate to guess he didn't claim compensation because it was his fault.
We would probably assume so, unfortunately, yes. Tony.
Now, he's on this tractor. He says to his father, "Dad, I've got to get off. I'm in a lot of pain." And his father said, "No, I can't jump on in your place. We've got 5 people doing the work and I can't cut it down to 4. He said that, didn't he?
Yes.
And that was very significant for him to win his case. Is that correct?
Well, the evidence is that the employer has directed him, in this case the employer is the father, directed him to continue working.
Okay. Now, Nardine, then what happened?
So what happened there, Tony, is that the Mr. Pasqualotto had attended the surgeon thereafter his injuries. From what had been led in evidence, his mother was also in attendance, and the surgeon at the time had emphasised to him that he should not return back to the tobacco work. And the evidence
or any heavy work.
And the evidence had also led that the parents had also had knowledge that their son had what we call a very light work back, and was quite susceptible to further damage.
Further aggravation.
That's right.
John, of interest, when he injured himself on the tractor, it was a different level, wasn't it? He injured the same level, but also...
A different level, yes, Tony. Yeah, exactly, on the spine. And Mr. Bresenor has, in his evidence, says he made it quite clear to the worker, you can't go back to heavy work working on the farm. And there's one notation whereby the mother was also in attendance. And that's crucial for later on, isn't it, Tony?
Yes, yes. In the first instance, the jury found no negligence, but negligence on the basis of a breach of statutory duty, which means what, Nardine?
Which means that due to specific guidelines in the statutory realm in WorkCover, that there was strictly no risk assessments that had been performed, mechanical assistance that had been...
Failed to comply with manual handling regulations.
That's right.
Tony, the jury found in favour of the worker, the plaintiff, the son in this case. Pain and suffering was awarded for $400,000 and future economic loss was awarded $444,000. But there's a sting in the tail, isn't there, Tony?
Yeah, and what was that, Nardine?
The jury had assessed contributory negligence by 70%, so therefore the award of damages was chopped.
Was shaved
by 70%.
So in essence, Tony, the jury accepted the defendant's argument, the employer's argument, that the worker himself had contributed to his own injury.
Exactly. In effect, what they're saying is that he knew he had a bad back, he should not have taken on that job. That's what they're saying.
Exactly. And of course, he appealed that, didn't he, Tony?
He did.
To the Victorian Supreme Court, Court of Appeal.
And a majority of 2-1 judges said that
Sorry, Tony, that there was a common law breach in statutory duty, and that it was almost impossible to not have discovered that at the first instance. Okay.
And so the court sent it back for retrial, John, on what issue?
Well, the court has sent this matter back for rehearing in literally the Supreme Court of Victoria on the issue of contributory negligence.
Is that the only issue, John?
Yes, Tony, on whether or not the worker contributed to his own injury. Now, crucially, the evidence of Mr. Bresenor, the surgeon, and the mother will be crucial. Now, at first instance, the court was had issue with the fact that the plaintiff had not called Mr. Bresenor, nor called the worker again to respond to Mr. Bresenor's assertions in regards to the attendance of the mother at the consultations. Now, it's going to be a very interesting rehearing, Tony, isn't it?
It is, and it's going to be very hard to confine it to this one particular issue. But the thing that concerns me is this. How do you determine when his damage occurred? Did it happen over the course of employment, or did it happen in that 1.5 hour where the father, he said to the father, "I can't keep working"?
Well, the surgeon, Mr. Bresenor, his opinion is it occurred over the course of employment.
Well, that doesn't help him on contributory negligence, does it, John?
Exactly.
If you could prove that it happened in that 1.5 hour, I don't think you'd take off much for contributory negligence, would you?
I would agree. I think it would be much more limited to a 70%. The 70% is almost unheard of assessment in this jurisdiction.
It's a very high assessment of contributory negligence. However, isn't this a case, Tony, where the jury have looked at all the facts, all the evidence, that in essence, we've got a son working for the family, for the parents. Now, and the jury has taken that into account in regards to whether orders were made and what orders were made. And that's the beauty of the jury system, isn't it, Tony?
Well, the finding almost comes back to say that he's voluntarily assumed the risk of injury.
Exactly.
That's almost what the finding is.
Exactly, yes.
You know, but there's another significant point about this, Nardine. If he doesn't get over a certain figure, he doesn't get his legal fees paid.
That's right.
He's got to beat that 90% rule.
That's right. So any prior statutory counter-offer, we usually would have to advise the client of the risks of litigation, of trying to beat that offer at trial, and should a percentage, such as 70% contrib, be discounted for the client at the instance, it means that he has to pay for the defendant's costs.
Well, in this case, there was no water asset cost because literally the 70% contributory negligence finding reduced his damages to the point where he did not receive 90%, within 90% of his statutory counter-offer. So it was a disaster for the worker.
It was.
That's why they're still pursuing it. The rehearing will be interesting, and it'll be only on the sole point, Tony, of whether or not the worker contributed to his own injury.
Well, I think that's an absolute Monty jump, because during the argument, I think the Workers' Council did say there was contrib. So the issue is going to be how much.
How much?
They didn't say you can't find contrib. He said there was. So the issue is how much.
Also, interestingly, Tony, the court did not consider whether or not you can have contributory negligence on a statutory breach claim.
I think that's going to be something for the future, John. But can I just ask you this? I have a lot of clients complaining that we're putting in counter offers that are too low. What is the significance? Who's going to tell me that?
Tony, the significance is it could be a disaster to the worker. If the worker does not receive within 90% of their statutory counter-offer, the worker does not receive their legal costs or a portion of their legal costs to be paid by WorkCover.
Which
and that's a disaster.
Very, very high, aren't they?
Well, we estimate around $25,000 to $30,000 a day in court per day.
Okay.
The legal cost to the worker. Now, that's massive.
It is.
And these trials can go for 2 weeks.
Nardine, thanks for coming on board. John, always a pleasure to have you on board.
Tony. Thank you, viewers.
Thank you.
Viewers, thanks for watching. Don't forget to go to our website, Twitter and Facebook, and go to YouTube and watch our past episodes. And don't forget to stay tuned for future episodes, and always remember to stay safe.